Gross. You're listening to Economics Detective Radio. My guest today is Samuel Gross of the University of Michigan Law School. Sam, welcome to Economics Detective Radio.
Great to be here.
So our topic for today is criminal justice. In particular, we're going to be looking at the issue of wrongful conviction. Dr. Gross was part of the establishment of the National Registry of Exonerations, which has provided valuable data in this area. So let's start by talking about the registry. What is it, how was it developed, and what was your part in it?
I'm the founder of the registry. It was created because after doing work on false convictions and exonerations for half a dozen years, it became clear that the only way to get any sort of systematic information on the exonerations that have occurred in the United States would be to put together the wherewithal to collect that information directly, because nobody else was doing it. There's no official system for gathering information on exonerations, or for that matter, a single legal definition of what is an exoneration. And from there, this project just took off on its own and became what's now a lasting institution that's in the process of handing over to other people to run.
Okay, so let's talk about the how an exoneration is defined in the registry. It's a case where someone has been convicted, and then later that conviction has been overturned, and presumably not just on a technicality, but because the person was actually innocent, somehow managed to prove their innocence. Is that correct?
Something like that. The problem with the thing that we're interested in studying is false convictions of people who were factually innocent. The problem is that there's no way to know when that's happened directly, because in cases where, by assumption, people have made errors, the jurors and prosecutors and judges who consider the cases have made errors in deciding who is guilty and who is innocent, it would be foolhardy and presumptuous and not particularly accurate for us to believe that we're going to be better at deciding after the fact which cases involve those sorts of errors and which don't. So what we've done instead of trying to make any judgments of our own about guilt or innocence based on whatever information we can collect from second or third or fourth-hand sources, what we do instead is to consider cases, to classify cases as exonerations if they meet the following criteria. First, the defendant has to have been convicted of a crime, not just charged. The conviction has to be completely removed. That is, at the end of the process, the defendant has to have no legal consequences from the original conviction, which means the conviction was entirely overturned by dismissal or by a pardon, or in a small number of cases, or by an acquittal at a retrial, or in a small number of cases by one of a few procedures that are available for people who are exonerated posthumously after they're dead. And then, in addition, the process that led to that result has to include substantial evidence of innocence that was not available at the time of the original conviction. If the case meets that criteria, we include it. If it doesn't, we don't. Our belief is, but it's a hypothesis, is that this produces a conservative classification for actual innocence, for errors in determining guilt at trial. We know of quite a few cases of people who were very likely to be innocent who are not included by these criteria. In particular, quite a few cases of people who reached that result, having the conviction entirely removed from the record without the production of new evidence of innocence. For example, cases in which the conviction was reversed and then later dismissed on appeal because there was insufficient evidence to convict at trial, unless some other evidence comes up before the conviction is reversed, don't generally count. And our hypothesis is that we include a very small number of cases of of guilty people who did meet these criteria. Although there are no doubt some, it's possible. But the process that it takes to get convictions reversed and dismissed in this manner in the United States is very difficult. And as a result, as far as we can tell, there are not very many misclassifications of people who did participate in the underlying crimes but meet the criteria for exoneration. But it's the best we can do.
Yeah, one thing I learned from your research is that the average time it takes a wrongfully convicted person to be exonerated is 10.1 years. So it seems like the system is stacked against it.
It changes depending on the mix of exonerations we have. At the moment, it's probably gone down a little bit, but yeah, that's about right. 10 years is close to the average still.
Yeah, looking through the registry, I noticed some interesting patterns that I wonder if you'd like to comment on. So, for instance, I was surprised by how few of these exonerations were about DNA evidence. It seems like it's actually more common for a witness to recant their testimony or for other non-DNA things, but I guess looking at media or just my own intuition, I would have thought that DNA would be the big factor in a lot of these.
And that's a very common misconception. I think most Americans think that exoneration is the second word of a two-word phrase that begins with the letters DNA. And that's, of course, as you know from looking at our data, not true. DNA exonerations have always been a minority, and in the past 10, 15 years, they're an increasingly small minority. The number of DNA exonerations has been relatively steady over the past 10 years, about 20 a year, and the number of non-DNA exonerations has been going up rapidly. The basic reason behind this is that DNA, which can be very telling and provide extraordinarily strong evidence of guilt or of innocence, is only valuable in a small range of cases. It depends on having biological trace evidence that identifies a particular person as the person who committed a crime. That's relatively straightforward in the case of sexual assaults, rapes in particular, where the trace evidence that's left is very hard to explain except as a consequence of the crime. So if you recover semen from the body of a rape victim and it's identified by DNA as coming from a particular person, and that person is not a consensual sexual partner of the victim, then you have the rapist. And if it's, assuming that a rape really did occur, but if it's a question of identity, which is the case in most of the rape exonerations we know about, that tells you both who the person is, if you can identify the profile, and in the case of exonerations, who it is not, because DNA comes asymptotically close to being a unique identifier and that type of DNA evidence. But that's rape cases. Some other violent crimes produce DNA evidence that's as valuable or nearly as valuable, usually murder cases in which there's blood evidence, sometimes other types of biological trace evidence, perspiration, epithelial cells from the skin, spit, other bodily fluids. And that can identify people under circumstances where you can determine from other evidence that the biological sample that was retrieved could only have come from the person who committed the crime. But most crimes don't have that. One of the things that's clearest in the registry, for example, is that there are almost certainly many, many cases of false convictions in robberies that are not exonerated because they don't have the type of evidence that's available in rape cases. And many in rape cases that aren't either. But both robberies and rape cases that result in exonerations overwhelmingly are cases in which the suspect was misidentified by a victim or by sometimes more than one victim. There are 3 to 5 times as many robbery cases of this sort as rape cases, maybe more than that. And they're typically cases in which errors are more likely because the victims may only get a fleeting glance at the robber, whereas rape cases, almost by definition, require much more close contact with the perpetrator. Nonetheless, despite the fact that the numbers suggest you have many more exonerations in robbery cases, rape exonerations outnumber robbery exonerations by about 3 to 5 to 1. And the reason is obvious, because the rape cases can be exonerated by DNA, but the robbery cases can't because you don't have DNA for the type of conduct that's involved in robberies. You don't have DNA that you can retrieve from threats that are made or guns that are waved or even guns that are used in shooting. And as a result, those cases are not exonerated at all. Now, given the huge disproportion between the cases in which DNA is valuable and cases in which DNA is never going to play any role, it ends up not surprising that the great majority of exonerations don't involve DNA. But the availability of DNA in the small number of cases, comparatively small number of cases in which it is valuable, does make those cases ones in which the possibility of correcting a terrible mistake is considerably higher.
So you mentioned the increase in recent years in non-DNA exonerations. I was looking at the data, and in 2011 there were only 73 exonerations in the registry, but by 2015 it had more than doubled to 157. So I wonder what's changed in recent years to make that number increase so much.
Well, there's a general change, and then there are a couple particular strands that stand out. The general change is that the resources that are devoted to reinvestigating cases where defendants were convicted and there are now doubts about the accuracy of the convictions are increasing year by year. And the willingness of everybody involved, criminal defense attorneys, but also, more important, prosecutors, police officers, and judges, to consider the possibility that someone who is convicted is innocent has grown greatly, have come to recognize that mistakes happen. And the more exonerations occur, the more people realize that this isn't just a once-in-a-lifetime event. And that's, I think, the force that is behind all of the specific changes that occur. The two strands that have made the most difference in these numbers are, in the last 10 years, I think, are in the past 4 or 5, a proliferation of conviction integrity units across the country, are specialized units within prosecutors' offices that focus on issues having to do with erroneous convictions. And for the most part, the ones that are most effective look at cases within that jurisdiction in which there is a possibility that the wrong person was convicted and work to reinvestigate and sometimes exonerate the people involved. They've contributed an increasing proportion of the cases that we see. And to the extent that this becomes more widespread, they might someday be a majority of all exonerations. There are something like 2,500 separate local prosecutorial offices in the United States. I don't have the exact count now. I will in several weeks, but my guess is that by now we have something like 30 conviction integrity units around the country, which represents a larger proportion of the population than that would suggest because some of the most populous counties. But it's still a minority of all cases where the local prosecutor has any organized interest in the issue. And then there's a particular pattern that came up in one county, Harris County, Texas, where Houston is located, that's contributed, I think it was 40-some exonerations last year and 40-some so far this year and 30 several the year before that. And that's a backlog of cases of defendants in Harris County who pled guilty to possession of drugs. And then after they pled guilty, the Houston Police Lab, Crime Lab, tested the substances that were seized from them to determine whether they in fact contained drugs, and found that the material that was the basis for their conviction included no controlled substances whatever. We ran into a number of cases of that over the years, but starting in 2014, the attorney who runs the conviction integrity in the Harris County District Attorney's Office noticed that there was a whole bunch of these cases and they were being handled very haphazardly, and put together a program to identify them all, to clear through the backlog, and to set up procedures for getting the defendants exonerated, and they're still working through that. The thing that's interesting about those cases is that that procedure, testing drugs that were seized from people or supposed drugs that were seized from suspects after the defendants have already pled guilty, is something that, as far as we know, doesn't happen anyplace else in the country, or didn't. Now I think a couple of other jurisdictions have begun to do it, at least occasionally. But it suggests that there may out there be thousands of cases a year of defendants who pled guilty to possession of drugs when in fact they were not in possession of any illegal drugs, although they could be exonerated by quite a simple process. It doesn't take an elaborate investigation, just running the drugs through the police lab, which could be done, except in Harris County, until the last year or two, nobody's ever done it.
That's so strange. Were they caught with a little baggie of oregano or powdered sugar and just everyone assumed it was drugs?
It's a whole lot of different things, but it's a good question. In some cases, they were arrested for possession of pills that were identified by the police officer as likely or actually being a controlled substance, often Xanax, and then tested by the lab and found not to be Xanax, sometimes ibuprofen, sometimes some other over-the-counter medication. In some cases, they had some amounts of white powder. One woman got written up in the paper had white powder on her face because she had the habit of eating flour, and had which some people do, eating flour mixed with water, and was left with some white powder around her mouth. In cases like that, where small amounts of white powder or something else were tested, they were subjected to field tests for drugs, which have become notorious in the past year or two because they are so unreliable. They are not admissible. Field tests for drugs are not admissible evidence in court to show that the substance involved was a controlled substance, but they're considered good enough to form the basis for an arrest. So then what happens is defendants who were arrested on these charges show up in court 3 days later, and if they can't make bail, which seems to be true in basically all the cases that we know about, perhaps with a few exceptions, then they're given a choice that amounts to this: plead guilty today, and you'll get, who knows, some perhaps a suspended sentence and go home immediately, or another week and you'll be home in 3 days, or something like that, or a short sentence. If you by Harris County standards, where drug sentences are very long, 3 weeks or 2 months or something like that, or plead not guilty, and then you'll be held in jail because you can't make bail for months. After which you'll go to trial, and if you're convicted, and obviously you might be because some cop in some test said you're in possession of drugs, then you'll get perhaps years in state prison. No doubt many people refuse to plead guilty in that situation, even because they're innocent, but some who are innocent do plead guilty, and those are the ones we find out about.
Right. So the process of being prosecuted for even when you're innocent can sometimes be more costly than simply pleading guilty, especially in these small cases.
If it's a low-level charge and you're held in pretrial detention, the process can be much more costly than a conviction after trial. You could, in Harris County, you could spend 6 months in jail or longer. So I've heard stories of people who spent a year or more in jail waiting for trial. If you can make bail, then that's still a heavy cost. Having a trial hanging over your head, having to come back to court repeatedly is not a walk in the park. But if you're held in jail for that period, it's an extraordinary cost. It obviously disrupts your life. It may tear your family apart. You will lose your job. You may not be able to get other employment, and so on and so forth.
So one of the things we've learned in recent years is just how easy it is for police to get people to falsely confess or to falsely accuse someone else of a crime. In fact, I think the number was 12% of the cases in the registry were false confessions, and I believe it was a majority involved a witness making a false accusation or committing some kind of perjury. Why do people confess to things they didn't do first?
Well, those are two different issues, false confessions and perjury or other false accusations, although there is sometimes an overlap. I don't think I agree with the statement that it's easy to get false confessions. In some cases, it no doubt is. But the false confessions that we know about are overwhelmingly in murder cases. And as far as we can know, but the information we have is not that good, they appear to be the result of long interrogations. The ones that really stand out sometimes take place over days, 2, 3 days or longer, with the defendant sometimes being questioned in relays by different officers. But even interrogations of 3, 4 hours or 5 hours, which is eternity if you're being questioned unrelentingly by police officers, are fairly uncommon. This costs the police quite a bit. It involves usually more than one officer over that period of time, and certainly one officer taking off that whole period of time and a fair amount of preparation. So it's not done very much, except in homicides. And it does happen in other cases, but I think 2/3 or so of the false confessions that we know about are homicide cases, maybe more than that. What's surprising is to many people, and we've gotten, those who work in there have gotten used to it, but it's still somewhat surprising, is not that it's easy to get people to falsely confess, but that people will falsely confess to murders that they didn't commit. And it had nothing to do with it. I mean, it seems like such an unbelievably strange and self-destructive thing to do. But it happens, and it happens time and time again. And what we see in these cases, and what other researchers have shown, is that it's much more likely if the suspect is in one of two general, very vulnerable categories. If the suspect's a teenager, or if the suspect has some type of mental disability, is intellectually disabled or mentally ill. Those two groups are, as far as we can tell, much more likely to falsely confess than other people who are subject to these interrogations. They are less likely to be able to resist the pressure. They're more likely to respond to authority. They're more likely to believe the promises and threats that are implied, if not directly made, in the process of the interrogation. They're more likely to become hopeless. And they're much more likely to not grasp the seriousness of what's going on. One of the most common things that people hear when they talk to a suspect who falsely confessed later on and ask, why did you do it, is, I confessed because I wanted to go home. I just told them what they wanted to hear so they'd let me go, which of course does not happen. Or I confessed because I just couldn't stand it anymore, so I told them what they wanted to hear, but I didn't think anybody would believe it. How could anybody take this seriously? And they think that because they're there and they've been experiencing this onslaught going on for a while, and they imagine that anybody who knows what happened would say, why would anybody take seriously what somebody says after hours of being badgered and humiliated and lied to? But of course, the jurors and the judge who hear the confession at the end typically don't know what happened, but they have a confession that has the defendant's name at the bottom.
Right. So the other thing I was asking about is the false accusation.
Right.
A lot of these come in child sex abuse cases.
Yes.
That's a pattern in the data.
Yes, that's correct. Child sex abuse cases are overwhelmingly cases in which there is no DNA or other physical evidence of the sex abuse. They're typically made, the accusations, the crimes are typically made anywhere from weeks to years after they occurred, way too late to collect any physical evidence. And that, as far as we can tell, is true of accurate as well as inaccurate child sex abuse accusations. The children who are victimized by adults are, ashamed and fearful, and many, perhaps a majority, probably never report the abuse at all. And those who do, everybody understands, will not necessarily do it right away. Sometimes have to be encouraged. But that means that false accusations are very hard to detect, because what do you have? I mean, you have a 9-year-old girl who says that her stepfather molested her in some way, repeatedly over a period of, a year or so, ending a year or more before she ever tells you about this. Nobody can figure out exactly what happened, what dates these occurred, where people were, whether anybody else could have observed it, etc. The details of crimes that occur in that context are essentially impossible to recover. Defending against it using evidence of timing or the presence of other people is generally impossible. It becomes a contest of credibility. And that means that if somebody is motivated to lie in this situation, and we see that in the cases that result in exoneration, the defendant may well be convicted, and that'll be the only evidence. And there are many of these cases in the registry. And they seem to often include cases which we don't find out about till years after the exoneration took place. They're often cases that got little attention at the time of the exoneration. I don't think we can come up with anything like an estimate of how common it is, but we do know that they're not rare.
Moving to a different topic, you co-authored a paper published in 2014 on the rate of false convictions among death row inmates. We'll
Correct.
link to that at the show notes page, economicsdetective.com/wrongful. I should say I first heard of this study when someone quoted a statistic from it, the statistic that at least 4.1% of death row inmates are innocent. And my first thought when I heard that was that it couldn't possibly be right, because nobody should have the tools to measure such a thing. But so I read the paper, and I was impressed with the method. So could you talk a little bit about the methods you used to get to that statistic?
Well, I have to agree with your initial intuition, because having worked in this area for decades, 20 years ago, I would have said this is not something that can be estimated. That is, the proportion of false convictions can't be estimated, because false convictions are by their very nature unobserved and for the most part unobservable. You can't just test to find out if somebody is innocent, or we wouldn't have false convictions. Now, a lot of things are unobserved, that we don't know the rate of proportion of prisoners in a prison who have been exposed to tuberculosis. But we can test that if we want to. We could test a sample. But this isn't anything you can test. So the question is there any way to come up with an estimate? And in general, it's impossible, because you don't have anything like the post-conviction information that will be necessary to come up with a clue as to how frequently innocent people are convicted. And for what it's worth, in the United States, our background criminal justice statistics on convictions in general are so bad that the comparison group of all people who are convicted is nearly impossible to define. Death sentences in the United States are just different, and they're different in two ways. First, we have, through the Bureau of Justice Statistics, a database that tracks everybody who's sentenced to death in the United States with reasonable precision from the time they're sentenced until the time they're removed from death row by execution, or by death from natural causes, or by exoneration, or by the most common means, which is being resentenced to life imprisonment. And second, we have an extraordinarily high rate of exonerations in death penalty cases, hundreds of times higher than for other crimes. I mean, just vastly higher. And the reason for that is, depending on your comparison and what you're comparing it to, perhaps only 10 or 20 times higher than other murders, but much higher than other felonies in general, and vastly higher than other misdemeanors. The reason for that is that someone who is under sentence of death is likely to have, almost always will have, access to resources to reconsider the possibility that he or she is innocent, that are simply unavailable to almost everybody else who's been convicted of a serious crime in the United States. They're going to be represented by attorneys, with few exceptions, from the time they're convicted until the time they leave death row. Their cases are all subject to review in appellate courts, which is not generally true of people who are sentenced to prison in the United States, and in almost all cases to multiple levels of review. The resources that are available to their attorneys are much greater. And probably as important as any of that, the legal system itself, and judges in particular, are much more interested in considering the possibility that people who might be executed could be innocent than they are in considering the innocence of anybody else, including defendants who are sentenced to prison without the possibility of parole, and are much more open to reconsidering cases when new evidence of innocence comes up. So the net result is a rate of exoneration that is vastly higher than any other type of case, which means that if you just look at the rate of exoneration and compare it to the overall number of death sentences that occurred in the time period where the convictions which produced these exonerations occurred, you already get quite a high number, about 2.3%, if you limit yourself to cases that are old enough so that by then anybody who will be exonerated probably was exonerated. That's a paper that one of my co-authors, Barbara O'Brien, and I published several years before the one you're referring to. So that already gets you to a number that you'd say is surprisingly high, but it's still going to be an underestimate. And it can be an underestimate because that fails to take into account the many cases of defendants who were sentenced to death, who were innocent, who will not have been exonerated. The paper you mentioned attempts to deal with that by focusing on one of the features of the process of exoneration and review of the cases of defendants who were sentenced to death. And that's something I already mentioned. If you're sentenced to death in the United States, chances are you will never be executed. What will probably happen is that eventually by one means or another, your sentence will be reduced from death to life imprisonment. You will be taken off death row and reassigned to the general prison population, and then you will die in prison, as do many defendants who are convicted of murder and sentenced to life imprisonment, but not sentenced to death. When that happens, the pressure to make sure that no innocent person is executed, which is the background motivation for the extraordinarily high rate of exonerations in death cases, is removed. The defendant is no longer under threat of death, and the extraordinary resources and attention that that defendant gets go away. And as a result, what you see is the death penalty exonerations that occur are overwhelmingly in cases of people who still remain under sentence of death and are on death row. And then once the threat of execution is removed, the rate of death sentencing drops back, as far as we can tell, basically to the same rate as other murder cases. So the question for us was, is there a way to estimate from the pattern of the cases that we know about, in particular their histories as they wend their way through this process, what the rate of exoneration would be if defendants who were sentenced to death remained under threat of death indefinitely, that is subject to the type of searching, investigation, and reconsideration that's available to defendants who might still be executed. And there is a technique for doing that, which you're very likely familiar with, and that's survival analysis. Figuring out how to do it with the data we had was a somewhat complicated process, but we worked our way through it, and that produced the estimate that you see, which is 4.1%. That's the point estimate. It obviously has a great deal of uncertainty attached to it, but it is a legitimate estimate of the rate of false convictions in that context, given an assumption the underlying rate of exoneration is a decent measure of innocence. And that requires a sensitivity analysis, which we also go through in the paper, and leads to, I think, a solid conclusion that this is a conservative estimate of the rate of innocence among defendants who are sentenced to death.
Yeah, death row inmates are innocent.
What is the point estimate? It's the lower bound of the point estimate, but I mean it really means something 3.2 to 5 point something percent. But it's hard to know what it means. But it means that it's somewhere in that range of 1 in 20 to 1 in 30, which I have to say was high by my lights. I was surprised at how high it was.
So where do you see this research program going in the future?
Well, unfortunately, I cannot see duplicating that type of estimate for any other category of cases because we do not have that information. We don't have the background information on the cases themselves, which is necessary to do the survival analysis. You actually have to know how many cases survived, what the trajectory of each case was through the legal system, and we don't have a glimmer of that except for capital cases. And second, the exoneration rate is much lower. So you can't make the leap from the exoneration rate to the false conviction rate would be much more tenuous. Our estimate at the end amounts to saying that we've detected something like 40% of the innocent people who were sentenced to death in this period in the United States. The rest, the great majority of them ended up in prison under sentence of life imprisonment or life imprisonment without the possibility of parole, and will probably remain in prison until they die. Some number of them were no doubt executed, although it follows from the same logic that leads to this estimate that will not be anything like 4%, that of the 1,200 or so people have been executed. They were being executed in proportion to the number who were executed who were innocent is proportional to the number who were convicted who were innocent. That would be like 50 or something like that. But since so much of the process is geared to avoiding the risk of executing innocent people, and that produces such a high exoneration rate, my guess would be it would be much lower than that. That would probably translate into executions of 10 or 20 or 25 innocent people over the past 30-some years. But that said, again, we don't know, and we can't say which cases they are. Can we do the same thing for robberies? or kidnappings, or for that matter, non-capital murders. I can't imagine how.
My guest today has been Sam Gross. Sam, thanks for being part of Economics Detective Radio.
My pleasure. Take care.
Show notes for this episode will be economicsdetective.com/wrongful. If you want to support the show, head on over to economicsdetective.com/support, where you can find various ways to support the show. The best, of course, is to support us through Patreon. Patreon is a service that allows you to make recurring donations to creators and people who create free content online, especially that you consume, such as this podcast. Special thanks to my latest supporter, Kyle. You may have noticed that, unlike many podcasts, there isn't a 15-second ad at the start and then jarring 60-second ad for underwear or mattresses in the middle of your podcast about economics. And the reason I can do that is because some people generously support the show voluntarily. I know advertisers would do it in return for jarring and irritating advertisements, and thus far I have not added any such things. And so you can thank Kyle and other people who support the show for that. Thanks for listening, and I'll be back next week.